He was born in Kansas, became a football star at the University of Idaho. He was married with kids when he decided to pursue his doctorate degree overseas. At the airport, he was taken into custody by the FBI. He spent 16 days in a cell. The lights never went off. He got no lawyer. For hours on end, he got no clothing. When they moved him from state to state, he was in shackles. After his release, he was forced to live with his in-laws for more than a year, checking with a probation officer, and his marriage ended. He lost his job with an Air Force contractor because that required security clearances. When the director of the FBI testified to Congress listing 5 victories against terrorism, his capture was one of them. But he was not held as a suspect. He was held as a material witness and never called to testify. The suspect in the trial was acquitted. The mistake Lavoni T. Kidd committed was being Muslim after 9/11 and trying in 2003 to travel to Saudi Arabia. The FBI got the warrant by telling a judge Kidd's ticket was one way, it was not, and first class, it was not. So now in our third story tonight, the Supreme Court today announced it will decide whether Kidd can sue then Attorney General John Ashcroft. Why Ashcroft? Because a month after 9/11, Ashcroft said he would use material witness warrants to try to prevent terror attacks. The Bush administration's roundup of Muslim immigrants, of course, was not an option for Kidd because he is an American citizen. Federal judges in Idaho and on the Ninth Circuit Court of Appeals have already said Kidd can sue. But the U.S. Justice Department is defending Ashcroft, arguing that he has absolute immunity. Arguing for Attorney General holder is U.S. Solicitor General Neil Cutshall, the same attorney who did so much from the outside to dismantle Bush administration abuses like this one, and a frequent guest on this news hour. Kidd's chances diminished considerably with the recusal of Justice Kagan due to her prior involvement in the case, also as Solicitor General. With us tonight about this, Jonathan Turley, scholar of constitutional law, George Washington University School of Law. Great, thanks for your time tonight, John.
Hi, Keith.
Overarching all this, the Obama administration's arguing the Attorney General of the United States has absolute immunity above the law?
Yeah, that's basically it. I mean, the amazing thing about this case is there's an old expression of bad cases making bad law. This is a case of a bad guy making bad law. I mean, they're going to have to pitch this to the hard right of the court to support one of the most abusive attorney generals in history. And what will be left is truly frightening. I mean, because this is a case, as you've mentioned, where false statements were given to a federal court to secure a warrant. A person was held without access to a lawyer, was held in highly abusive conditions. And you also have an attorney general who was virtually gleeful during that period about his ability to round up people. You know, this was at a time, as you know, where the material witness rationale was being used widely and rather transparently to simply hold people. And what's fascinating about this, Keith, is, you know, Smith, the judge here, wrote a really incredible opinion. It's one of the better opinions I've read in the last 10 years. And he notes at the end, this is basically what the framers fought against. And he's right. That is, we've become what it is we fought against, what it is we defined ourselves against. This is what the framers were talking about, arbitrary detention. And my God, you now have the Obama administration arguing that you can't possibly hold an attorney general liable for such an egregious and horrible act.
Especially with Justice Kagan on the sidelines for this, is it safe to assume that the conservative court's going to undo what all the lower courts have said and give that absolute immunity to Ashcroft and all the other attorneys general for time immemorial?
I think it is, unfortunately. The Obama administration knows that it has an excellent chance of creating this new precedent. And when you pile it up, it truly is frightening, because the administration has already said it will not investigate torture. It has already said it will not prosecute torture. It has already dismissed dozens of cases, including cases for victims of torture. Now it is saying that even people that order abuses, that clearly should have known that they were abuses, cannot be held liable. And you're left with this curious scene of Obama officials expressing concern over why liberals are so lethargic in this election, like it's something that we said. Yeah, it is. I mean, this is a truly, it's not a disappointing act by the administration. I got to tell you, I find it a disgusting act to try to create this type of precedent. And I promise you, this precedent will bear a horrible fruit, and this will be repeated because of what President Obama and his administration are going to do before this court.
And do I have this correct, that in essence the reason there is a case against Ashcroft, or the Attorney General in this case, would be that because he announced beforehand he was going to stretch the material witness law and then stretched it, it's premeditated?
Well, you know, what the court here said was, you knew that this was illegal. This was well-established law. So you went out and broke the law, and now you're coming to us and say, but I can never be sued at any time under the sun. That is the precedent that President Obama may soon be establishing.
Jonathan Turley of George Washington University. Always a pleasure, even when we're talking like this. Thanks, John.